I hired in at Goodyear Tire and Rubber Company in Gadsden, Alabama, February the 5th, 1979.
Lily Ledbetter. She worked for Goodyear Tire and Rubber in Gadsden, Alabama for almost 20 years. Toward the end of that time, she got an anonymous tip on a slip of paper. Turned out she was being paid less than men doing the same work. A lot less.
I was shocked because there was so much difference in their pay versus mine.
By the end of 1997, Ledbetter was being paid $44,700 a year, while her male counterparts were making 25% more. She sued.
I thought and believed that if I had a problem, that I could carry it to a court system, whether it be local or federal or to the Supreme Court.
Okay, you can name one more.
Jump to the year 2000, Louisville, Kentucky. Children thriving at a great school. Why? Because of a local school board's voluntary plan to integrate. A plan like hundreds of others across the country, enacted by elected officials who, with popular support, chose to pursue the vision of one nation, indivisible.
80% of the parents said that they were in favor of the managed choice program that we had, that we were implementing.
All they were doing was trying to assure that every school had a mixture.
I like learning new things, and I like meeting new people.
But some families didn't like the school board's program. They sued to end it. What do these two cases have in common? This place, the Supreme Court of the United States, where Americans have sought justice for over 2 centuries, where an ordinary person can stand equal with the government, with a large corporation, with the rich and powerful, with the protection of our laws and our Constitution. Almost a century after President Lincoln ended slavery, Black Americans still suffered many forms of discrimination. Among the worst, segregated schools. In 1954, the Supreme Court declared unanimously such separate schools unconstitutional and ordered the integration of public schools. Brown versus Board of Education. It served us well for more than 50 years. And in 1965, Congress went even further, enacting the Civil Rights Act. It prohibited discrimination in employment, not just on the basis of race, but also on the basis of sex. Applying this law, a jury of Lily Ledbetter's peers awarded her compensation for the pay discrimination she'd suffered while working for Goodyear.
The jury had understood what we were telling them. They saw the proof, and there was no doubt.
Who could disagree? The Goodyear Company. It appealed the decision, arguing that the law said that such cases must be brought within 180 days. They said that 180 days started when Ledbetter received her first discriminatory paycheck, even though she didn't find out about the discrimination until 16 years later. So Lily Ledbetter wound up before the Supreme Court, and so did voluntary integration programs in Louisville and Seattle. And there they ran into a problem. President Bush had recently appointed 2 very conservative justices, John Roberts and Samuel Alito. And despite the lower court rulings and the Supreme Court's own precedents, they ruled against both the Louisville schoolchildren and Lily Ledbetter.
A major legal setback for workers in this country, the Supreme Court limiting employees' ability to file a lawsuit against pay discrimination.
In a narrow 5-4 split, sided with Goodyear and handed big business a major win. But Justice Ruth Bader Ginsburg
took exception to the majority's decision. She quoted the Supreme Court's own precedent, which said that each discriminatory paycheck is illegal, not just the first one. Besides, she said the decision was unrealistic. Goodyear prohibited all its employees, including Ledbetter, from discussing their pay. She'd had no way of learning the truth until long after the discrimination had begun. Ginsburg concluded, "This court does not comprehend or it is indifferent to the insidious way in which women can be victims of pay discrimination."
She was exactly right, and I knew that she knew where I had been and how hard it is, and I felt like that she had been mistreated through the years as well.
Just a month later, school children experienced the same sting of injustice.
The Supreme Court ruled today that race cannot be a factor in assigning children to public schools, and the conservative majority that made that decision was, of course, partly shaped by President Bush, a mark wolf of one of his legacies.
Today, as Elaine just noted, the court issued what will likely be a landmark decision, one that some say threatens the historic decision a half-century ago that outlawed racial segregation in schools.
It is a betrayal of Brown. It's a decision which promotes segregation, which stands in the way of voluntary desegregation.
Louisville and the Seattle school systems were doing was attempting to improve the educational prospects of all the kids, because this is truly a multiracial society now.
And I find it very ironic that what the court originally ordered Jefferson County Public Schools to do, it's now ordering them not to do.
I felt that the children, again, would not get the equal opportunity if we went back 50 years ago. I'm thinking we're going backwards instead of forward.
I think it's almost a stabbing it back to public education.
But both Alito and Roberts were well coached for their confirmation hearings.
Do you believe that the Constitution protects the right of children in America to be educated in schools that are not segregated?
Absolutely, Senator. That was one of the greatest, if not the single greatest thing that the Supreme Court of the United States has ever done.
So do you agree with the court's conclusion that the segregation of children in public schools solely on the basis of race was unconstitutional?
I do.
They pledged to be open-minded, fair, and to respect precedent.
I need to decide those questions with an open mind on the basis of the arguments presented, on the basis of the record presented in the case, and on the basis of the rule of law, including the precedents of the court.
They misrepresented to the American public and to the Senate their intentions, and that they're really not concerned about precedent, about continuity and stability, about assuring the American public that the laws will be equally applied, equally interpreted, and that they will seek to protect the rights of all Americans.
And the presumption is that the court will follow its prior precedents. There needs to be a special justification for overruling a prior precedent.
They turn Brown on its head. They actually say that the lesson of Brown is that you can't use these actually rather modest measures to integrate the classrooms. And that's a perverse reading of Brown.
Is gender discrimination, as you've written in a memo, a perceived problem, or is it a real problem?
Of course, gender discrimination is a serious problem. It's a particular concern of mine.
Those justices had no idea what it was like in the real world, working in a factory, trying to scrounge out a living, and to be a female at that.
And I will remember that it's my job to call balls and strikes and not to pitch or bat.
As much as I respect your metaphor, it's not very apt, because you get to determine the strike zone. What's unreasonable? Your strike zone on reasonable or unreasonable may be very different than another judge.
I think John Roberts should have been ashamed for analogizing the Supreme Court justice to an umpire. Anyone who's been around courts, and John Roberts certainly knows, that Supreme Court justices are anything but umpires. Umpires don't make the rules. The Supreme Court justices do make the rules. I think John Roberts used that analogy to try and make it seem at the start of his confirmation hearings like his views don't matter, and that therefore there's no need to talk about his views during the confirmation hearings. We've seen in his 2 years on the court that his views matter enormously, as any justice do, and he has very conservative views that constantly reflected in his decisions.
This isn't about calling balls and strikes evenly. We're talking about the opportunity to play the game. I think the decisions that have been made in these past few months by the Supreme Court compromise the ability of people to have the opportunity to play the game fairly.
These are dark days for Americans who look to the Supreme Court to protect our basic rights and liberties. The Ledbetter and Louisville decisions show clearly what the radical conservatives on the Roberts Court have in mind: an ideological agenda, little regard for the court's own precedents, even less for the values of equality and fairness that animate our Constitution and our laws. Justice Breyer put it this way in his dissent in the school case. It is not often in the law that so few have so quickly changed so much.
This court had 5 votes, bam. They're going to rewrite every case that comes before them as much as they can.
And this is not a restrained court, but it's essentially a court that is furthering the Republican agenda through another branch. And that's especially true of Bush's appointments.
They're not patient, they're greedy. They're not careful about how they're reshaping the law to accommodate their values. They're moving very quickly and very hungrily with little thought for the ability of the country to assimilate the change. They exude contempt for those of us who disagree with the views of the 5.
John Roberts is the youngest Chief Justice in 200 years. Samuel Alito is just a few years older. They could be making decisions for decades to come. But that must not stop us from doing whatever we can to protect liberty and to seek justice.
Unfortunately, most people don't realize that what the Supreme Court decides affects their lives on a daily basis. For women, whether or not there'll be access to safe legal abortion depends on who the justices of the court are. For the millions of people who are victims of discrimination, well, whether there's going to be a remedy depends on who the court is. For people who have a loved one who's a defendant in the criminal justice system, whether there's really going to be a fair system under the Constitution depends on who the justices are. And I think we need to do a much better job before the 2008 election of showing people that one of the most important, maybe the most important thing the next president is going to do is determine whether we'll have justices and judges who will enforce the Constitution.
This is not just about politics or some abstract issue of the law. This is about justice. This is about human beings, like Lily Ledbetter, a woman who has worked hard and honestly all her life. Not famous people, but Americans, entitled to justice.
Fairness. Fairness.
We need to bring fairness to every American. You, me, a student in Louisville trying to learn, or a woman in an Alabama tire plant just hoping to be treated fairly. This is our time, and this is our place. We cannot turn our backs on the struggle when we see a court turning its back on justice. We cannot ignore the need to defend the Constitution when we see the courts ignoring its words. So get involved and get active, for among the senators voting on judges is your senator. Among those who seek to be president will be your president. Don't just hear them out. Let them hear your voice. That's how we bring fairness to every American.